What did Pretrial Chamber 3 decide regarding Burundi?
On the 25th of October 2017, Pretrial Chamber 3 of the International Criminal Court authorized the ICC prosecutor to open an investigation regarding crimes allegedly committed in Burundi or by nationals of Burundi outside of the country. The decision was exceptionally issued under seal, that is to say confidentially and only accessible to the ICC prosecutor. Since on the basis of available documentation, the past and present circumstances in Burundi and neighboring countries establish that there is a danger to the life and well-being of victims and potential witnesses. A version of this decision was made public on the 9th of November 2017. The pretrial chamber found that the court has jurisdiction over crimes allegedly committed while Burundi was a state party to the ICC Rome Statute. By ratifying the statute, a state party accepts the jurisdiction of the court over crimes committed either by its nationals or on its territory, starting from the moment the statute enters into force for that state and running up to at least 1 year after a withdrawal instrument is deposited. This acceptance of the jurisdiction of the ICC remains unaffected by a withdrawal of the state party from the Rome Statute. As a consequence, the exercise of the court's jurisdiction, namely the investigation and prosecution of crimes committed up to and including the 26th of October 2017, is possible even after the withdrawal became effective for Burundi. Pretrial Chamber 3 considered that the supporting material presented by the ICC prosecutor offers a reasonable basis to proceed with an investigation, noting that according to the available information, there is a reasonable basis to believe that crimes under the ICC jurisdiction have allegedly been committed, such as murder and attempted murder, imprisonment or severe deprivation of liberty, torture, rape, enforced disappearance, and persecution as crimes against humanity. And that according to the available information, and despite the establishment of 3 commissions of inquiry and proceedings before domestic courts, the Burundian authorities have remained inactive in relation to potential cases arising out of the situation in Burundi. The reason was either because the domestic proceedings did not concern the same persons that are likely to be the focus of an ICC investigation into the situation in Burundi, or they did not concern the same crimes as identified by the pretrial chamber, or that national investigations were deficient. In other words, there is no conflict of jurisdiction between the ICC and Burundi. The chamber also noted that the potential cases are of sufficient gravity and that an investigation would be in the interest of justice and of victims. The chamber noted that, according to estimates, at least 1,200 persons were allegedly killed, thousands illegally detained, thousands reportedly tortured, and hundreds disappeared. The alleged acts of violence reportedly resulted in the displacement of more than 413,000 persons between April 2015 and May 2017. The pretrial chamber 3 is composed of judges Chang-Ho Chung from the Republic of Korea as presiding, and Judge Antoine Kessia Mbe-Mindua from the Democratic Republic of Congo, and Judge Raoul Pangalangan from the Philippines.
Does Burundi have an obligation to cooperate with the ICC after its withdrawal took effect on 27 October 2017?
Yes. The pretrial chamber's decision was issued on 25th of October 2017. That is to say, prior to the date on which Burundi's withdrawal became effective, which is the 27th of October 2017. And thus, according to Article 127 of the Rome Statute, which specifically governs states' withdrawal from the treaty, Burundi has a duty to cooperate with the court for the purpose of the criminal investigation which commenced before the 27th of October 2017. In the view of the Chamber, any obligations on the part of Burundi arising out of the decision authorizing the opening of the investigation would survive Burundi's withdrawal. The obligation to cooperate remains in effect for as long as the investigation lasts and encompasses any proceedings resulting from the investigation. Burundi accepted those obligations when ratifying the Rome Statute. In case of a non-cooperation, the Court may make a finding to that effect and inform the Assembly of States Parties of this non-cooperation for the Assembly to take any measure it deems appropriate.
Can Burundi challenge this decision?
Even though Burundi, which would normally exercise jurisdiction over the alleged crimes, did not enjoy any participatory rights during the authorization process, it is possible for Burundi to ask the ICC prosecutor to defer the investigation. According to Article 18 of the Rome Statute, Burundi may inform the ICC prosecutor within 1 month after having been notified of the initiation of the investigation that it is itself investigating or has investigated its nationals with respect to the criminal acts which may qualify as crimes within the ICC jurisdiction and which relate to the information provided in the notification by the ICC prosecutor. At the request of Burundi, the prosecutor shall defer to Burundi's investigation. Should the ICC prosecutor disagree with such a request presented by Burundi, she would be under the obligation to reapply to the pretrial chamber for authorization of the investigation. Burundi or the prosecutor may appeal the subsequent decision of the pretrial chamber before the ICC appeals chamber.
Did the chamber take the victim's view into account in its evaluation?
Yes. Despite the fact that the chamber could not receive victims' representations, the chamber was guided by the views expressed by the victims in the communications sent to the prosecutor and submitted by the prosecutor to the chamber. In particular, communications received from civil society organizations and legal representatives of victims. These communications had been received by the prosecutor during the preliminary examination phase, and the victims overwhelmingly speak in favor of opening an investigation and provide many details about the alleged crimes. The chamber ordered the ICC registry to notify its decision once public to the victims or to associations representing victims who have communicated with the court in relation to the situation in Burundi.
What are the crimes that may fall within the scope of this investigation?
The pretrial chamber found a reasonable basis to believe that state agents and groups implementing state policies, including the Burundian National Police, the National Intelligence Service, and units of the Burundian Army, operating largely through parallel chains of command, together with members of the youth wing of the ruling party, known as the Imbonerakure, launched a widespread and systematic attack against the Burundian civilian population. The attack targeted those who opposed or were perceived to oppose the ruling party after the announcement in April 2015 that President Pierre Nkurunziza was going to run for a third term in office. The chamber found a reasonable basis to believe that Burundian state agents and members of the Imbonerakure committed at least the following crimes against humanity. First, murder and attempted murder. According to estimates, no less than 1,200 individuals were killed between April 2015 and June 2017. The main perpetrators of these killings are reported to be the Burundian security forces as well as members of the Imbonerakure. The crimes were mostly committed in Bujumbura, but also in other provinces and even outside of Burundi, and the existence of at least 9 mass graves was reported in 2016. Second, imprisonment or severe deprivation of liberty. Thousands of persons have allegedly been arrested and detained in violation of fundamental rules of international law by police and intelligence officers, often assisted by members of the Imbonerakure. Third, torture. In the period between April 2015 and April 2016, between 595 and 651 cases of torture were documented, taking place in particular in the detention centers of the intelligence services, the police, and unofficial places of detention. Acts of torture appear to have continued also into 2017. Fourth, rape. Dozens of cases of sexual violence committed by police officers, military personnel, and members of the Imbonerakure have been documented since April 2015. Some of the victims are reported to be as young as 8 years old. According to the material submitted, women who fled the country in particular were subjected to sexual violence near the border by members of the Imbonerakure and others, as a punishment for leaving the country. Rape has dire consequences for the victims, not only from a medical, but also from a social point of view, as women who have been raped tend to be abandoned by their husbands when they later learn of the rape. Fifth, enforced disappearance. The Chamber noted the multiple instances where members of the opposition, members of the civil society, and young men suspected of having participated in demonstrations or of belonging to a rebel movement were removed from the protection of the law and have been abducted, arrested, and detained by members of the security forces. Their whereabouts remained unknown for months and sometimes years afterward. Sixth, persecution. The Chamber found, on the basis of the available information, that the crimes of murder and attempted murder, imprisonment or other severe deprivation of physical liberty, torture, rape, and enforced disappearance constitute persecution. In addition, the Chamber found that the government and the security forces had also banned demonstrations, harassed journalists and members of opposition parties, and suspended or revoked the licenses of civil society organizations. The Chamber held that these crimes and acts amount to severe deprivations of fundamental rights, contrary to international law, such as the right to life, the right to be free from arbitrary arrest and detention, the right not to be subjected to torture or to cruel, inhuman, or degrading treatment, freedom of expression, freedom of association, and freedom of assembly. The Chamber further held that this persecutory conduct was directed specifically against an identifiable group or collectivity based on political grounds. These crimes were allegedly committed in Burundi and in certain cases outside of the country by nationals of Burundi and started in April 2015. The pretrial chamber indicated that in the light of the continuous nature of certain crimes, the prosecutor may also extend her investigation to such crimes even if they continue after Burundi's withdrawal became effective. By the same token, under certain circumstances, the prosecutor may also extend her investigation to crimes that were committed before April 2015. The authorization given to the ICC prosecutor allows her to investigate the above-mentioned alleged crimes, and depending on evidence, the investigation might be extended to other crimes against humanity, war crimes, or genocide, falling within the parameters of the authorized investigation.
What are the next steps?
The Office of the Prosecutor will collect the necessary evidence from a variety of reliable sources, independently, impartially, and objectively. The investigation can take as long as needed to gather the required evidence. If sufficient evidence would be collected to establish that specific individuals bear criminal responsibility, the prosecutor would then request the judges of Pretrial Chamber 3 to issue either summonses to appear or warrants of arrest for these persons.